Hello and welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss the judgment of X versus Principal Secretary, Health and Family Welfare Department, NCT Delhi. It's a recent case which came out in 2022. So if you're preparing for any of the LLM entrance exams, do check this case out as it could be important under constitutional law. Before we start with the judgment, there's a small announcement. We are organizing the second CLAT PG open mock competition. It's free for all. It is on 20th November 2022. So if you're interested, do click on the link below and register yourself for free. Now coming to this judgment, in this case, the appellant is a 25-year-old unmarried woman who seeks to terminate her pregnancy, and she approached the Delhi High Court for seeking permission for termination of her pregnancy before the completion of 24 weeks, which is the statutory limit under the MTP Act. The relief was denied by the High Court, citing that her case is not covered under the MTP rules of 2003. Therefore, she has filed an appeal against this judgment of Delhi High Court. Now, there are two main issues which are involved in this case. First is whether she is entitled to relief of termination of pregnancy as per the MTP Act and rules or not. Second is the interpretation of MTP rules read with the MTP Act of 1971. There are different legal provisions which are involved, but there are two important provisions that we will keep on seeing again and again. Section 3 of the Medical Termination of Pregnancy Act and Rule 3B of Medical Termination of Pregnancy Rules 2003. Now let's start with some of the main findings of this case. So in this judgment, the argument of the appellant was that since her relationship status has changed during her pregnancy, as her partner has refused to marry her and has left the relationship, so she should be entitled to seek termination of pregnancy under Rule 3B of the MTP rules. Now Rule 3B as it exists provides for change of marital status during the ongoing pregnancy as a ground for termination during 20 to 24 weeks. So the Supreme Court in this case held that there is no rationale in excluding unmarried women from the ambit of Rule 3B of MTP rules. The court said that the recent amendment in the MTP Act has diminished the difference between married and unmarried women seeking termination of pregnancy under this Act. So a narrow interpretation would be violative of Article 14 of the Constitution. Therefore, the court has read Rule 3B as also meaning that if there is a change of relationship status during the ongoing pregnancy for an unmarried woman, then her case will also be covered under Rule 3B of the MTP rules. Another important observation was with respect to Section 3(2)B of the Medical Termination of Pregnancy Act of 1971. Again, interpreting this provision in light of the objective of the MTP Act, the court held that Section 3(2)B provides for termination of pregnancy till 24 weeks of women if it causes risk of injury to her mental health. The court held that an unwanted pregnancy can be construed as injury to mental health of the woman. There are some other important findings as well. The court has interpreted a few more provisions of the MTP rules and has held that rape under the MTP rules, which is a ground for seeking termination of pregnancy, also includes marital rape. It is important to note that marital rape as it exists under the IPC is not a criminal offence as of now. So the court has held that rape will also include marital rape, but this observation is solely for the purposes of the MTP Act, and a woman need not seek recourse to formal legal proceedings to prove sexual assault, rape or incest in this case. A few more findings are with respect to minors and their termination of pregnancy. The court has held that Rule 3B includes minors within the category of women who may terminate their pregnancy up to 24 weeks. However, the registered medical practitioner need not disclose the identity and other personal details of the minor in the information provided under Section 19 of the POCSO Act. So the decision in this case was that the appellant was granted the relief and she was allowed to terminate her pregnancy, and also the court has interpreted the MTP rules in line with the objective of the MTP Act, and it has held that no discrimination is permissible on the basis of marital status under the MTP Act and the MTP rules, especially after the 2021 amendment to the MTP Act. The court has also reiterated that right to reproductive autonomy forms part of Article 21 of the Constitution of India. So this brings us to the end of our video. If you like this video, please like and share and subscribe to our YouTube channel.